Welcome to the Vintage Times, a program for older persons. On our program today, we will talk about legal issues of concern to older people, such as living wills, durable powers of attorney, and more. It is very important that each one of us plan ahead for a time when we may be unable to make our own decisions concerning our health care, our finances, and other personal matters. It is equally important that we communicate these wishes to persons who will have to make decisions on our behalf at a very difficult time. A recent survey published by the Township Salt Council indicated that a significant number of older people do not have these important documents. We will talk about living wills, and durable powers of attorney and other legal issues with Eileen Fitzgerald, who is an attorney in Downers Grove, and Eileen concentrates in elder law. Thank you, Eileen, for joining us again. We've had you before.
Thank you for inviting me.
You're welcome. Can you describe our profession to us, please?
I'm an elder law attorney, and an elder law attorney helps clients with legal issues that affect them as they age, and also we help disabled people.
Oh, good for you. Now, Eileen, as I mentioned before, many older people in our area do not have important documents such as we mentioned. Is it important to have wills, living wills, powers of attorney, and so on?
It is important, and it's especially important that they do those for their family. You know, it helps the family to know what needs to be done if someone becomes disabled or somebody passes away. It puts it in writing and just makes it so much easier for your family.
And it makes it easier for the people who have to make the decision.
Correct.
Yeah.
Right. So if you, for instance, doing the powers of attorney, you're putting in writing what you want done. So that helps your family to know that they're making the right decision for you.
Yeah. It's a difficult time.
Does
it help to talk to the family and tell them that you have executed these where they are?
I usually tell my clients that yes, once they have done the documents, I'm assuming they've talked to their families about them already, but like for the healthcare power of attorney, to give them some suggestions and some scenarios. If this happens to me, this is what I would want you to do. Some clients give their children copies of the documents. Some clients are not comfortable with that, but the children should at least know where the documents are and be able to access them.
Yeah, that is so important. I have done them, and I can tell you it's a big relief to have executed these documents and to have told my children what my wishes are and where the documents are. And I think they're relieved also.
Right. I get clients, they tell me that all the time. It's a big relief once it's done. They've been thinking about it for years, and people just put it off, but once they do it, they're happy they did it.
Right. So, do it.
Right.
Now, can we go into detail about the types of documents that are important to execute?
Sure. I think wills are important, or trusts. Basically, those two documents will tell your family how you want your estate distributed after you pass away. It's also important to do powers of attorney. Those documents are documents that you sign for any potential disability. So for the healthcare power of attorney, you're telling your family what you want done medically. For the power of attorney for property or for finances, you're giving someone the authority to handle those finances if you can't do it because of some type of disability.
Some people confuse wills with living wills. What's the difference?
A will is a document in which you name an executor who's going to control your estate after you die, and you tell how your estate is to be distributed after you die. A living will has to do with your health care while you're still living. So the living will tells your doctor that you don't want life support and that you want, your family to carry out those wishes for you.
Or that you do want life support.
Basically, a living will says you don't want life
You
support.
don't want
right.
it.
So,
Okay.
so that document, if you sign the living will, that's saying that you don't want life support.
Okay.
If you sign a healthcare power of attorney, you can go, choose either way if you do or you don't want it. But
So the power of attorney for health care is more detailed.
right, right.
So what things does it cover, for instance?
There's a place on the form where you can say if you want organ donation. They recently changed our form here in Illinois last year, so they included that if you don't want to donate organs, they now have a place where you can do that. That's one of the
Okay,
choices.
You have a choice.
Right.
Okay.
There's also choices regarding life support. So there's 3 choices on the form regarding life support, whether you want life support or you don't. You're also naming your agent who's going to make the medical decisions for you. You're naming who's the successor agent in case the first person can't act for you. And you can name as many agents as you want, but you can only name one at a time. Our form here in Illinois is only
Okay.
one at a time.
Okay.
So, I usually suggest to clients also that they can add other information in that power of attorney for healthcare. For instance, if they want to be cremated, we can put that in the document. If they have specific directions regarding their funeral that they want, this is the place to put it, not in your will. If they have other directions that they want to give regarding healthcare, things they do want done, don't want done, any specific religious beliefs, this is the place to do it. Many times my clients will talk about tube feeding and whether they consider that to be life support or not. And then they'll put a specific direction whether they want that or not. So those
Okay.
are just some of the things.
So there are many things to think about. I can imagine if you don't have it and your children have to make decisions, not knowing what your wishes would have been must be difficult and maybe even confusing, and it can cause
Right.
disagreement.
Right. Yes, because once you get 2 or 3 people together, they may not agree, on
Yeah.
what needs to be done. So if you have it in writing, that's important because again, your children may not agree, and you think they will, but once it comes down to it, the time when something's happening in the crisis in the family, that's when things get difficult.
It's a difficult decision, so it's important that they know what you want, not what they want.
Correct. And you should make sure that the person that you appoint is going to carry out your wishes.
Your wishes.
That that they can do that.
Yeah.
That if you don't want life support, that they can carry out those wishes.
Right.
Because again, it's not an easy decision.
Right.
But so you need to pick the person that can do it.
And you can always say, Mom said, that's what Dad said. So it
Right.
relieves you of any possible guilt.
Right.
Eileen, are there recent changes concerning powers of attorney?
Yes. So the one that I talked about for the power of attorney for healthcare, for instance, was that you can choose not to have
Okay.
organ donation. But there's other changes too. The forms now indicate that by signing a new power of attorney, you're revoking the old power of attorney, which
Oh.
wasn't in our old forms, which is very helpful. I put it in my forms, but it wasn't part of the Illinois
Oh, I
statutory
see.
form.
Okay.
So that's very helpful so that you don't have, 2 or 3 powers of attorney out there with naming 2 or 3 different
Oh,
people.
that's true.
Right.
So it's the last one
Right.
that revokes the previous ones.
Correct.
That's very interesting.
It is. Yep.
That's just for powers of attorney.
Right, but typically your will says that too. When you do a
Okay.
will, it says I'm revoking any prior wills. So,
Okay. Now, what happens if I don't have these documents?
if you don't have, for instance, a power of attorney for healthcare, Illinois has what's called the Illinois Surrogate Act, and that act allows a person who's named a surrogate to make medical decisions for you. And in that statute, there's a hierarchy of people that are named who can make those decisions. If you have a guardian of your person appointed, that would be first. If you have a spouse, that person's next. And then they go on down the line until they find someone in that hierarchy
Okay.
who is willing and able to make decisions. So that's for medical. If you don't have, for instance, a power of attorney for property and someone needs to have access to your money that just has your name on it, then they're going to court and having a judge appoint a guardian for you.
So it's a legal process that your heirs have to go through.
Right.
And
And again, that could cause some, disagreement among the family as to who's going to be the guardian, whether the parent needs a guardian, who's going to control the money.
Yeah,
So,
right.
so it can be a confusing time. It takes time. It takes money to do that.
And it can create unpleasant conversations, can create friction.
Right.
Does it take longer to?
It does take longer because if you have a power of attorney, that can be in effect right away, whereas the guardianship can take, depending on where you're doing it, anywhere from a couple weeks to 6 weeks, for instance.
Okay.
And that's assuming that there's no disagreement among the family.
And how difficult at that time to start this process.
Right.
Yeah. I can see where it's very helpful to have an attorney because you really know what to do. But do I need an attorney for this?
That's an interesting question. I think you should have one. What I find is when people do the documents themselves, they don't do them correctly. So sometimes I'll have clients, who've done the documents, they want me to review them, or a family comes in with documents that a parent has done, for instance, and they're in a crisis situation, and they need to use the documents, and they're not done appropriately. Illinois has specific rules regarding how documents have to be witnessed or notarized. With wills, there's specific language, a specific number of witnesses, and if it's not done correctly, then it's not going to be a valid document here in Illinois. So I think it's well worth their money to pay for an attorney to prepare the documents for them.
All of these documents.
Correct.
Yeah.
Yes. Yep.
Okay. Well, that's good advice. It's well worth the money, as you say.
Right.
We talked before about not executing living wills and powers of attorney. What if I don't have a will? What happens then?
If you don't have a will, Illinois has a statute that decides for you how your estate is going to be distributed. So, for instance, if it's a husband and wife and they have a couple children, and one of the spouses dies, Illinois law says that half of that spouse's estate goes to the surviving spouse and half of it goes to the children. Now, that's typically not what my clients want to do. They want to leave everything to their spouse.
Right.
Also, if you're leaving it to children and those children are minors, that's a whole nother set of issues.
Right.
Because you can't leave, children can't inherit if they're minors, and so we would have to set up a guardianship in the court for those minor children. So it brings up a whole slew of issues. So.
Not only that, it makes me realize that everyone should have a will. It's not just older people. You
Right.
just mentioned younger children.
Right.
Then
Right.
it becomes a
Right. I
big-
think it's important for younger people to have it too. Really, anybody over 18 really should have any of these documents. They're considered adults in the legal world. As far as, younger clients, yes, we typically do wills for them that includes trusts for their children because, again, minor children can't inherit. So we want to have a mechanism in place
Right.
so that someone can take care of the money until the child is of an age where they're able to do it themselves.
so important. Now, you mentioned a trust. What is a trust?
A trust is a legal document in which you name a trustee who manages the assets for you during your lifetime, during any potential disability, and then again after death. And you can be your own trustee initially, and I'd say most of my clients are. They want to handle their own assets themselves. But if you don't want to for some reason, you can name another person, you can name a bank or a trust company to handle the assets for you. And
Why-
it's a way to avoid probate too.
Do you have to decide who the agent would be? Is it you have 3 children? How do you decide whom to choose? Is that difficult?
I think for some of my clients it is difficult, but again, I tell them don't just name your oldest child because you think that's the person that you should name. It really should be the person who you think will best administer the assets for you. I had a client in recently who there's 3 children, and she's the middle daughter, and she is the one who can get along with both siblings, whereas they may not get along with each other. So that's a good person to name. And if that person is also good at, handling finances, is organized, can keep good records, that would be an excellent person.
Yeah. So it takes some thinking. Should you communicate this to your children that it's not easy, but I named my middle child
Right.
because,
Right. I think it makes it easier on everybody if you tell the children ahead of time what you're doing.
right,
I think if they're surprised after you pass away, or they're surprised if you're, in a nursing home and disabled, that just adds to, some family disagreements. So I think
Right.
if everybody knows ahead of time what's in writing, that's good for family harmony.
how do you communicate all this to your children? Should you have a family conference, or do you have any advice on that?
I think that's one way you can do it. I've had clients do it, when the family's all together for holidays, and, it may not be the best, topic of conversation, but it's really something that needs to be talked about.
Right.
So if you have the family together for holidays, that's the time to do it. And again, if there's, family who their children are in different parts of the world or different parts of the country, that's
a
oftentimes
good
when
time.
that's a good time
Yeah.
when they're together.
Yeah.
So,
And you'll feel better after it's done, right?
Right.
You mentioned before, but let's just be sure again, should we review these documents every so often?
I suggest to my clients that they do it at least every couple of years. Unfortunately, a lot of them will do the documents and then kind of put them away. And it's like, I've done it, I don't have to think about it again. But I think it's good to review the documents every couple of years. If there's changes in your family situation, that may necessitate you having to change your documents. If there's changes in the tax law or the size of your estate, if you got an inheritance, that may necessitate you to change the documents too. So I think it's a good idea to review everything. Clients seem to forget what they've done. They forget who the beneficiary is. They forget, who they've named. And again,
Right.
circumstances change. So I think they should review them.
Every what?
I would say at a minimum every 2 or 3 years.
Yeah.
Yeah.
If you've done it with an attorney, go to the attorney.
Right.
You will help me review them. You will know about
Right.
changes maybe in the law.
Right.
Yeah.
Right.
Okay. What changes did you say? Family changes?
I would say family changes, were there any divorces in the family? Were there any additional children born or grandchildren that might necessitate changes in your documents? Any family disagreements that might have come up? So things like that may necessitate, how you want to handle your documents and who
Yeah.
you want to be in control.
A lot to think about.
It is a lot to think about.
Another aspect of healthcare is Medicaid. Many people are on Medicaid and get healthcare through Medicaid.
Right.
Are there any changes we need to know about?
There actually have been some changes to Illinois' Medicaid laws. The federal law changed back in 2006, and Illinois has finally caught up. And as of January 1st this year, we are conforming with the federal law. The big change is for when you're applying for Medicaid, and this is basically for people in a nursing home, there's a 60-month look back. So it used to be 3 years, and what that means is from the time that you apply for Medicaid to pay for your nursing home care, they're going to go back 5 years and look and see what you've done with your assets.
Oh.
So they want to see copies of bank statements, copies of brokerage statements, copies of IRA statements, basically a paper trail for your assets for 5 years. And they're looking to see, have you given any assets away so that you could qualify early for public aid. So that's why they need to see that. And they're very specific. They want to see all the bank statements. They want to see every page of the bank statement. Even if the bank statement page is blank and there's nothing on it, they want to see it. If there's any checks over $500, they want to see that too. They want to know what that's for, because again, that could be a gift.
What if they do find that I transferred money in order to get on Medicaid sooner?
If they do find that, they're going to penalize the person, and the penalty is that Medicaid isn't going to pay for their care for a certain period of time. And that's one of the other big changes that occurred. The penalty now goes into effect not when you made the gift, but when you apply for Medicaid and you no longer have money. They're going to say, okay, we will not pay for your care. You will not get Medicaid benefits for, let's say, for 6 months. from the time you apply, 6 months going forward, we're not going to pay for your care because you gave away this money, a year or two ago. So that's a big change in the way that they do the penalties.
So just to clarify, maybe some people don't know what Medicaid is and what it pays for. Can you explain?
Medicaid is a federal and a state finance program, and it pays for, with my clients, it pays for their nursing home care basically. So when they go into a nursing home, Medicare may pay up to 100 days, based on their condition, but Medicare, that's all that they're going to pay for, is maybe the first 100 days. After that, you're either on private pay, or if you don't have any money, you apply for Medicaid. So Medicaid will pay for the nursing home care for people that don't have much money.
Okay.
And there are spousal impoverishment rules, which allow the spouse who's at home to keep some of the assets, because we don't want to spend all the money on the person in the nursing home and then leave the spouse at home with nothing. So under the Medicaid rules, the spouse at home is allowed to keep certain assets, including the home, a certain amount of assets, a certain amount of income, a prepaid funeral, a car, personal belongings, so that spouse at home is allowed, has some assets to live on.
What that means is if my spouse is on Medicaid in a nursing home, I'm allowed to keep a certain, how much money am I allowed to
Right
keep?
now, the spousal asset limit is about $113,000, and the spousal monthly income limit is about $2,800. So
Well, that's pretty good.
the Medicaid rules are very specific, very detailed, and everybody's situation is different. There's a lot of exceptions, so that's definitely an area where you want to see an elder law attorney, because everybody's situation is different. So even though, I just gave some examples of what the asset and the income limit are, there's a lot of exceptions.
Yeah.
So you need to talk to someone who is familiar with the Medicaid rules.
So if you feel that, at what point you decide maybe I should apply for Medicaid?
I've had clients who, have a spouse who went into a nursing home, and, I had one just recently, a spouse who went into a nursing home. They don't have a lot of money, and basically what money they do have is going to go to the spouse at home. So basically, that person's in a nursing home, and when Medicare stops paying, they're going to need to be on Medicaid benefits. So that's, when they would want to do it. But I also have clients who come in who have a spouse who's been diagnosed with dementia, let's say early stages of dementia, but they want to know, what's going to happen. Do I need to make sure I have all my documents in order? What's going to happen? Is the spouse at home? What are they going to be allowed to keep? So they're very proactive in getting their things done and finding out what's going to happen in the next few years.
There's so much to think about. Let's just review the important documents we need to execute. We need to fill them out, have them signed, maybe have them notarized.
Right.
Let's just review them.
I think at a minimum you should have a will, a power of attorney for health care, and a power of attorney for property. If you want to avoid probate, then you should talk to your attorney about signing a trust also. So those are the minimum documents that you should have. Yep.
Yeah, and if you do have them, it's important to review them.
Right. To review them every couple years, to let your children know where the documents are so that they have access to them. If they're in a safe deposit box, for instance, make sure that somebody else's name is on the safe deposit box.
That's right.
So that they can get into the box too.
Can you make copies and distribute them to?
You can. Like I said, some of my clients are comfortable doing that, giving their children copies. Some aren't, so it's just up to them. If you have a regular doctor, you might want to give him or her a copy of your healthcare power of attorney. And if you go to the hospital for tests or surgery, you would certainly want to bring a copy of it with you.
Bring it with you.
Right.
Otherwise, they may ask you to complete another one, right?
Exactly. Right.
Yeah.
Yep.
So, amazing how much we can prepare in advance to just know that our wishes are abided, that our finances are in order, and our health care will be in good hands. Eileen, is there anything else of importance you'd like to add?
I think I'd just like to encourage people to do the planning. It makes it so much easier for your family if you've done the planning. Makes it so much easier for your spouse and for your children. And by not doing it, you're really causing them a lot of problems.
Yeah.
So,
Well, thank you very, very much. And thank you for joining us today. We hope you learned how important it is to have legal documents prepared in advance for a time when we may not be able to make a decision. Other people will have the difficult task of deciding for us. So these documents are very important. If you would like to contact Eileen, she's in Downers Grove. Her phone number is 630-493-4380. You can also contact the Lawyer Referral Service of DuPage County of the Bar Association at 630-653-9109. I also want to tell you that we have documents at the township. They are the durable power of attorney for health care and for property. But again, it's very helpful to see an attorney to be sure that these documents are executed properly. You can also then call us at the township at 630-719-6682. And thank you again for joining us today.